name is Frank Musica. With me are two of the trustees of the AIA Trust, which is co-sponsoring this webinar. The trust has officers from firms of all sizes. So with me today is Brad Benjamin from Radium Architecture in Greenville, South Carolina, a relatively small firm, and Glenn Birx of Air St. Gross in Baltimore, a relatively large firm. And as I said, my name is Frank Musica. I'm third on that list. As background, I started my life as an architect, and for a decade worked in small and large architecture firms. I also spent time as a lobbyist for the AIA in government affairs. And about 30 years ago, I joined Victor as a risk manager, where I can use my background in architecture, business, and law to educate policyholders and provide them with practice management tools. As part of my work here at Victor, I serve as an insurance counsel to the AIA Contract Documents Committee. Actually, Victor has had someone on that committee since 1963. Now, before we get into the 10 contract issues our speakers will address, I want to provide you with a quick look at American law and how it treats you as a design professional. It took me 2.5 years in law school to learn what I will teach you in about a dozen slides. There are two things you have to understand about American law. The law protects reasonable expectations of the parties. Whether you're driving a car, whether you're signing a contract to provide your services, whether you're selling a good, the law protects reasonable expectations. And if you do not meet those reasonable expectations, if it's considered wrongful conduct, you are responsible for the foreseeable costs of that wrongful conduct. You're responsible for the harm you cause. Now, in design practice, think about these two things. Everything you do on a design is about trade-offs, right? In most terms, it's trade-offs about money, how much is that project going to actually cost, time, and quality. And that makes it difficult at times for those who are not familiar with the building process to understand the trade-off between reasonable expectations and what you do as a licensed design professional. Now, when you're a licensed design professional, you sign a contract, especially an AIA contract, you're really providing 3 different services, and the law treats those services in different ways. Most of what you do is provide consulting services, right? You're looking at the needs of the owner, you're looking at design constraints, the laws, the codes, the standards, and you're developing design recommendations. That's what you do when you do plans and specifications. Those are recommendations to the client. You're not selling the client a good, right? You're not guaranteeing the result. You're giving recommendations to the client in your instruments of service, and the client has to buy into that. Now, in a normal contract, you then step into a different phase. And that phase is you're a representative of the owner. You serve in kind of an agency position. And you do that not to administer construction of the project, unless you're a construction manager. You do that to administer the contract between the project owner and the construction contract. You're managing that interaction. And those construction phase services are very important, but they're treated differently from just providing consulting services. Because in this case, you have, you're a representative of the owner, and it's the owner who has to take responsibility for what you do. Now, the third thing you do in most contracts, at least in the standard AIA contract, is you may serve as the initial dispute neutral. You can have someone else assigned to that, but usually on architectural projects, the architect is the initial dispute neutral. And what you're doing in that case is you're the first person the owner and the contractor will come to resolve a misunderstanding or a dispute between them. And if they accept your recommendation, the project moves on. If not, there are other contractual provisions that allow, for instance, the contractor to bring a claim against you. When you do that, the law treats you entirely differently, because if you do it in good faith, you're seen as kind of a judge. It's a quasi-judicial capacity. So the law really treats you in different ways depending on what the role is on the project. Now, on any project, we have to talk about determining fault and liabilities. And part of that is done through tort law. And that's basically what professional liability insurance covers, because that's a legal framework for professional liability. And professional liability covers you for your liability in the performance of professional services. That's based on a standard of care. And the reason that is based on the standard of care, why professional liability insurance coverage is based on the standard of care, is that an insurance company has some idea of what's reasonable in the services you provide. It doesn't know what you sign in every contract. And we will look at some of the contractual provisions later on where you can get yourself into a lot of trouble. But the insurance company is not going to accept that trouble from you, because it is only looking at what is reasonable, what harm you might cause if you do not meet the standard of care. So professional liability covers your tort law exposure. But of course, you can have contractual law exposure. And in this country, you have great freedom to assume obligations. And when you sign a contract, you're really creating private law between you and your client, not between you and the rest of the world, between you and your client. And often that contract may have forced you to accept the risks that exceeds your normal legal liability as a design professional. And if it does that, it's outside of your scope of professional liability insurance coverage, and maybe outside of the scope of your many other insurance coverages.
Hey, Frank, this is Glenn.
Mm-hmm.
I just wanted to say that that's the introduction to the term contractual liability, which we are going to talk about a good bit later today, and is one of the biggest confusing factors for clients and for owners' attorneys, and is something that we are seeing often language coming in requiring that kind of contractual liability. But the point to remember that Frank just said is that since this is outside of the scope of our insurance coverage, this is something to be avoided in contract negotiations, and we'll show you some examples of that later on in this presentation.
Right, or it's a risk that you can determine as a business risk, and you might charge extra for it, you might do other things to handle it, but it's not going to be covered by your professional liability insurance. Let's talk about tort law, because again, that's the basis for professional liability insurance. And what you have in any liability is, first, is there a duty and a breach? And in tort law, that's negligence is a failure to meet the standard of care. And that creates the first part. It breaches your duty to your client or to a third party. But the second thing you have to look at is, does it cause damage? Remember, we mentioned foreseeable costs. And tort liability is based on the foreseeable damage practically caused by negligence. Right? So if you're negligent, you may not harm anything. You may not cause a problem. You may not add to the cost, in which case you're not liable even though you're negligent. Now, in determining that, if you ever went to trial, you would look at jury instructions like this. And this is from the DC government. And it addresses professional liability in general. As you can see, it talks about doctors or lawyers or architects or many others, right? And a jury is told that you're not negligent as a design professional if you adhere to the standard of care. And the jury has to decide whether the defendant was negligent by deciding whether the defendant failed to perform according to the professional standard of care. And the question that they have to answer is, did the defendant do what a reasonable and prudent professional in the field would have done under the same or similar circumstances? Now, how does a jury know what that is? It knows that through expert witness testimony. And I think, Glenn, you served as an expert witness, right?
I have many times, and it's a very interesting thing. I think many architects should do that just to learn more about the system in depth. And it's very scary, frankly. And the question, that Frank posed is, does the defendant do a reasonable and prudent professional job? Well, how in the world is a judge who is not an architect or in the design professions at all, or a jury who is farther away from that than a judge, make that determination? They have no idea. So the process is through the use of expert witnesses that both sides will hire. Frankly, as an architect, it's very frustrating to listen to architects saying two different things about the same events, but that is what happens in a judge or a jury trial. And other techniques we're going to talk about later today are trying to avoid a trial, which is a very good thing because of this. I remember the first jury trial that I participated in. It was a jury trial, and I watched the jurors' eyes during the entire process, including the closing arguments, and they were glass. They had no idea what either side was talking about. And it even, as an example of that, is the outcome. I won't tell you the names of the parties, but the outcome was this. My firm filed suit against a design build client for unpaid fees. They countersued us for $1 million and some dollars for errors and omissions. The jury came back and first said we rule in favor of the plaintiff, number one. And so we began celebrating that we were awarded our additional our fees that we were under contract for. But then they went on to say we also find for the defendant and award him the $1 million for errors and omissions. It's just a clear example of them not understanding what happens and a good reason to avoid a jury trial. So therefore, it's really not about who's right and wrong. And it's helpful that you might have the best paperwork to prove and make your point, but in reality, it just comes down to a decision made by jurors or judges that who made the best presentation, who they believe the most to make the point about whether the standard of care was followed or not.
Thank you, Glenn. And that really is an issue of credibility. When a jury then has to award a verdict, as Glenn said, it looks at what the expert witness said, try to determine what is the standard of skill and care, and then if it decides that the defendant did not follow that, it looks at, the fact that the defendant did not meet the standard of care, did that cause an injury, harm, cost, loss, damage to the plaintiff? And as Glenn said, that's a very difficult thing to determine. And that is why many clients will do everything they can in the contract to say, I don't care about determining whether you're negligent or not. I just want you to pay me, okay? And we'll look at some of those provisions. We need to look at contract and warranty law briefly, because again, that's one of the things we'll be talking about. Contracts, again, they're relatively easy to set up. There's some things in a professional service contract you should be careful about: scope, compensation, time. But any contract is just mutual assent of the parties. Some exchange of legal value. Consideration doesn't mean that they like you. Consideration means that they promise to pay you, or that they have paid you, or that you will perform services. But the parties have to have a legal capacity to contract, and it has to be a legally permissible objective. Obviously, you can't sign a contract to do something that violates codes and standards, not legally permissible. And you may have problems in your contracts because you may sign a contract with someone who has authority to sign a contract, But later during a project, someone who's the owner's project manager or project advisor will come to you and ask you to do something else. Let's add to your scope of services. And if that party did not have the legal capacity to change your contract, you may be performing those services for free. But let's look a little bit more about what contracts mean. Again, start with duty and breach. In a contract, that just means the failure to carry out the terms and conditions of the contract, right? And it takes a substantial failure to actually breach a contract. And the question is, what's the causation and what's the damage? And in the contract, liability is to provide a remedy for harm caused by the failure to meet the contractual obligations. This says nothing about meeting the standard again. This says nothing about whether you're negligent or not. This just says you made the deal. If you breached the deal and there was harm, you're responsible for that harm. Now, a special kind of contract law is really warranty law. And warranty law is just made on promises. And you can get yourself in trouble in a contract quite easily. Just give you some examples. We saw this a lot in sustainability issues, where an architect will, in the contract, tell the client that this project will have 50% energy savings over similar projects, right? That's a promise, you know, and it doesn't matter whether or not you met the standard of care. If you made that promise to a client and that project moves more than 50% energy that a similar project would use, that means your statement was false. And if that client had reason to rely on it and did rely on it, it needs to be able to collect damages. And we have seen plaintiffs, owners, say, look, you told me this would save 50% of my energy costs. This building has a 50-year life. It hasn't saved 50% of the energy costs. That's a major harm to me. And I want you to pay me the difference over those 50 years, right? Because you made the promise was false, owner relied on it, otherwise they wouldn't have built the project. It proved false, and now how do you solve that problem? So you can get in a lot of trouble with warranties. And we'll talk about warranties as a contractor provision. And then you also have to look at who can recover, how much can they recover, and how long do they have the right to recover. And you probably know, if you're a practicing architect and you violate a code or standard, you were negligent, anyone who's harmed could bring a case against you. You know, that woman who steps on the steps that were improperly designed, that did not meet the standard of care, but were built according to plans and specifications, can sue you, right? Your client obviously can sue you. How much can they recover? Well, that can be enormous, because they're not only recovering direct damages, the cost to make something right, but they could recover huge consequential damages. And consequential damages are things that flow from the actual error that you made, right? So if you're negligent and your negligence leads to that dormitory at that university not being available on time, perhaps there was something wrong in some of your specs, you had to withdraw it, you had to redesign, that held up the project. The project isn't able to be opened in time for the fall semester when people actually went to schools and lived at schools. And that university now had to go out and rent hotel space for all those students who would have been in that dormitory. Whose fault is that? That extra cost is because of your negligence, and you could be held liable for it. Now, how long before exposure ends? You probably all know that almost every state has something called a statute of repose. Vermont and New York don't, but every other state does. They vary in years from 4 to 10 or 15, maybe. That exposure your exposure to anyone could be cut off by those statutes of repose. But you have to be very careful whether the services you're providing actually are within that statute of repose. Statutes of repose were put in to protect contractors, not design professionals. They do protect design professionals. But even in a contract, we won't use this provision in our examples, but you could agree with an owner that the owner can sue you in perpetuity. The owner may change what would normally be a statute of repose and say, okay, I have 2 years after I find a flaw in what you've done to sue you. And that may override a statute of repose put in by the state legislature that says at max they have 10 years to sue you. So 20 years from now, if there's a problem, you could be sued for it. And we've had cases in states like New York where a mistake made 30 years earlier resulted in a recovery against the architect. So you have to be very careful about knowing when exposure ends. And you know that you're in business. When you're in a professional practice, you not only have professional liability issues to deal with, you have contractual and you have other business exposures. And most of these are not going to be covered by any professional liability policy unless for some reason they're tied to your negligent performance of professional services. Not simply your negligence, right? If you drive a car negligently on a site and you damage something, not a professional liability claim, you better have the right auto coverage. But there's fraud, misrepresentation, concealment of material fact. Now there's an increased effort by some clients to say that you're not only a consultant to them, you're not only an agent of them during construction, you're actually a fiduciary to them, which is a much higher standard and one that someone who handles money usually has to meet. So there's all these other things that can affect your exposure on a project, right? So we will talk about some of the contractual issues, but remember that you have to deal with all of these things when you're in business providing professional services. Okay, let's look at some of these contractual and business risks. These are the ones we'll be looking at. Our speakers selected 10 that they thought they could cover during this short period. So let's get right to that.
Frank, let me jump in here and just say that, yes, we did limit this to these 10 intentionally. I mean, not to say that there aren't others. There are plenty of other particular issues worthy of being talked about, but we feel that these 10 issues, if we are aware of these 10 things that we're going to go over, that will cover the vast majority, 90% or more of the common contractual issues that come up in negotiating with clients.
And certainly the ones that could damage you to the greatest extent.
Yes, correct.
Okay, so let's look at this. Remember we said you had to meet a standard of care. Well, sometimes clients want to define that. They may have something as simple as you will meet the highest standard of care for this project. You may get yourself in trouble because you actually had that kind of thing in your marketing information. You may have held yourself out as meeting highest standards. The problem is that there is no measurement of highest standards. When Glenn was talking about serving as an expert witness, and if he said what an architect normally, or what was reasonable, what was in the scope of what an architect would do, he could not really testify. And this firm met the highest standard because in doing that, he would have to say, this firm is better than absolutely every other firm that could do this project. So when a client demands that, is it aspirational? Does the client say, gosh, you told me you were great. I hired you because you were great. So let's meet the highest standard. Or is it targeting? Because many attorneys for owners will put this kind of simple language into a standard of care provision because they know you can't possibly meet it. And they have one breach of contract claim against you, they're true. So you have to be very careful in that kind of language. And there's, multitude of things like that.
So Frank,
yeah.
Frank, I'll say that this word, the insertion of the word highest, we are seeing that a lot now. It's not, I mean, it is very common for attorneys to add that to an owner contract. You have to watch for it. I've talked, many of my clients when I've balked at that have said, well, all the other architects that have worked for us have signed that. And it is a real issue that we have to be aware of, not for just for ourselves, but for the profession. And I will tell you this, that not only are we not insured for the highest standard of care, but the definition of highest, which Frank alludes to there, made by your opposing attorney, is literally, you're the best ever that's been done.
Right,
and the best. There is no one that will do. Everybody else is lower than you. You will be the highest, and that is a contractual requirement that is, as you can imagine, impossible to meet.
Right. And the other part of that is, I threw this in because similarly to highest is when the client says, you are my fiduciary, which in some states could be as simple as saying, you have to deal with the client in the utmost trust and confidence, because that's basically saying the same thing. That's basically saying you will do better than anyone else. Every cent I have that goes out on this project, you're responsible for. So if you do something that causes an increase in cost, you've breached your fiduciary responsibility. Now, you've probably seen the normal standard of care provision in the AIB 101. We're not going to read these other slides. There's a lot of information in this slide deck that we want you to keep on hand so you can reference it. So now, when you see a standard of care provision that's unrealistic, go back to the AIAB 101 and look at what it says.
And Frank, I've spoken with owners' attorneys about this language and why they add some of the things. Oftentimes, attorneys don't have a lot of experience in construction and design fields, so they will go to the AIA documents to start. And then when they read this, they will say, wait a minute, what do you mean ordinary care? I'm not representing my client to get you ordinary care. That's why they then scratch out ordinary and put in highest, right? And the other things that I've seen, in addition to that, by taking this language that from the B101, is large firms or firms that have done name your building type before, this is where they add the word highest in front of the professional skill. And then I've often seen attorneys take this language, but then add additional language requiring certain warranties and guarantees that they think belongs in this clause too. And that just gets us to this contractual liability and warranties and guarantees, which we're going to cover shortly.
Right. Yeah, so be very careful. Obviously, if you hold yourself out as having an expertise in healthcare or an expertise in some other type of project type, the owner may want that reflected in the standard of care. Well, that makes sense because you're now being compared to a different group, but you're not meeting absolute standards. You're still compared to your peers. So you may have a special expertise. You may advertise that special expertise. You may entice a client to hire you because of that special expertise. They refer to that special expertise in the standard of care. You're probably safe. It's when they come up with the absolute phrases that you're going to get into trouble. Let's talk about contractual defense and indemnity issues because and here's a good example. A client asking you to defend the client against any claim related to the project. indemnify you for costs, losses, and damages in any way related to your services. Remember when we said about foreseeable costs? So if you do something that doesn't meet the standard of care, that's wrongful conduct, and you're responsible to correct the harm caused by that wrongful conduct. But remember, that's tied to negligence. It's not tied to the project, right? Any claim related to the project could be anything. And you're not indemnifying the client for costs, losses, and damages related to your services. You're reimbursing or indemnifying the client for costs, losses, damages to the extent they are caused by your negligent performance of your professional services. So keep that in mind. And some of the things you have to think about is, can you preempt this tender of defense obligation? Can you just give the owner what your insurance policy covers so they understand that? Part of it is this issue of, is it CGL or PL? And how do you manage those exposures? And Brad, I think you've had problems with this in your area facing these kind of defense and indemnity provisions, right?
I have. When I get a contract, the first two things that I look for are standard of care and indemnification. And then in the indemnification clause, I scan for it and look for two more words, defend and negligence. And like you said, one you want and one you don't want. You do not want defend, and you do want it tied to negligence. And recently I had to negotiate a contract with a local municipality, and it did have negligence, but it also had defend. So I told them I would not be able to sign it this way because it has defense and my insurance does not cover that. And again, like Glenn said a minute ago, the response was, well, all the other architects signed it. And I did not want to challenge them on that because I doubted that. But I did say that I don't have cheap insurance. All the architects and engineers that you are negotiating with have this same exclusion, and the large ones may be able to defend you under certain circumstances, but me being a small firm, I can't cover that. And I would rather go ahead and tell you this is something that I can't do than to go ahead and sign this and then tell you on the back end, well, sorry, I can't pay to defend you, and you'll have to sue me to get those, recover those fees if I'm not held negligent. And the procurement officer said, I have never heard that. So I think it's not always where the client is trying to get one over on the architect, not always, but sometimes they just don't understand how our insurance works. And some architects just go ahead, I've got the job, I'll sign it, and I'll roll the dice and take my chances. And I'm just not willing to sign a contract where I agree to execute myself, because if they triggered that defense clause, I literally would have to declare bankruptcy. There's no way that I can afford to do that. And I think a lot of architects out there are in the same boat.
Now, you have to understand that there are statutes in some states that prevent the defense obligation from being put into an architect's contract. So check your state statutes. Part of it is, if you're working for a public agency and they ask you to defend them, can they really turn over the defense of a public agency to a private party? Because if they do that, they're really violating the taxpayers' trust in it. Because they need to defend the taxpayers' interests, not you. And here are some things you can do if you see it. And Glenn, I know you've had some success with this third one, bifurcating the provision. Could you explain a little bit more about what that is?
Yes, and that is an important win that we can obtain in negotiating these contractual defenses. And what it does is recognizing the fact that our CGL policy does not prevent us from agreeing to a defense obligation where our professional liability does. So therefore, by this language that Frank has placed here, if that can be added, that's a really good compromise with your client that gives them, or the client's attorney, that gives them an understanding that we are can provide that kind of defense and have insurance to cover it, CGL, but it bifurcates the professional liability insurance for those things because it does not cover it. And this is a very good compromise that I've had a lot of good success with recently.
Yeah, in fact, some state contracts, like I know in Kansas City, for instance, they actually do very carefully bifurcate.
Yes.
And some developers will do this because they understand that when it's a slip and fall, when it's a CGL type coverage, usually the interests of the owner and you are pretty much aligned. But when it's a professional liability policy, the interests aren't aligned. And therefore, having the AE defend the client just doesn't work. So, partially it's a coverage issue. We would have to charge a lot more if we also defended your client. And part of it is just there's not an alignment of the interests on most of these situations. And you probably know there. The AIA has for years, decades, avoided putting a contractual indemnity obligation in their contracts. And the reason they did that is because they did not want to make it easy for the other party to simply change a few words and make it an extremely onerous provision. Because even if there's no contractual indemnification agreement in your contract, you still have that duty to correct harm to the extent caused by your negligent services. That's basic to American law, even if it's not in the contract. So for the large project contract, B103, this is what the AIA added. Finally added an indemnity provision. But if you look at it very carefully, it is tied to your normal negligence. And in the 2017 version, they added the part that it does not include a duty to defend, to make that clear. Right? They also added this last part, which is the limitation on liability, which is a very sneaky way to limit your liability. Okay.
Frank, back to that slide real quick just for a second. As Brad said earlier, one of the things, we always look at rewritten indemnification provisions coming from owners, and it makes our heads spin. And I've also had success by saying that, complaining about that, trying to negotiate the language, and then going back to this language, which comes from AIA, where we can say this is the standard language of the industry. This is put out by the AIA. This is the standard way to give you the indemnification you want that's insurable and makes sense and is reasonable and is the standard of care. So I've had good success in eliminating attorney drafted indemnification clauses by proposing this one.
And keep in mind that attorneys often will slip the same kind of provision in about 5 different places in the contract.
Right.
So
Yes.
if you catch it under the title defense and indemnification, you may not catch it in other places as well. Let's talk a little bit about insurance issues, because it really is a professional liability insurance is different, and many, even lawyers working for clients, don't understand the specifics of professional liability insurance, even though their insurance is very much like your insurance as a design professional. So when a client says, we want your insurance limits to apply specifically to this project, right? Or that they say, we want your limits to apply and we want defense outside of those limits, you may have a problem. And clients will often say, just as they do with other types of insurance, which makes sense if you're doing auto or CGL, that they want to be named as an additional insured. Now, if it says limits specifically applicable to the project, that's not your normal practice policy. Because when you buy insurance, you buy in a per claim limit and an aggregate limit for that entire policy. So that applies to every project you do, right? And you could have one project that you have a major claim on, and it erodes your aggregate limit. So if they want it specifically to that project, it either has to be something called project-specific insurance, or there has to be some kind of an additional limits endorsement on your policy for that one project, right? For defense costs usually are within the limit. And firms like Len, they are always within the limit. For smaller firms, up to perhaps $1 million in billings, you can actually buy defense costs outside the limits. Yes, Len, you had.
And there's two common problems that we see in many contracts these days. One is this additional insured issue, and it's just not possible, right? And even when you say that to an owner or his attorney, you still have to convince them. One way I've gotten over that is by having a letter on hand from my broker. I could probably get it from Victor as well, but it's probably more powerful coming from the broker because they do represent other insurance companies that basically says no one can provide this additional insured for the PLI. And as Frank was talking about earlier, this literally moves you into a breach of contract. If you sign a contract that says you will provide them, name them as an additional service, and then you can't do it, that's technically a breach. Right. And then similarly, we still see, believe it or not, requirements that our PLL policies are per occurrence, which is no longer available, of course, for many years. But we can only purchase the per claim policies now. So it's the same thing. You'd be in breach if you signed a contract. And as Brad and I both said a couple times already, we always hear back from clients, well, other architects have signed this and they've never complained about it. So it's up to us, all of us, to inform them of the real truth about these policies.
And a lot of times I feel like it's just because they just don't understand. They think that gives them a greater security, but they just don't understand the nuances because most people don't procure architect and engineering professional services on an ongoing basis enough to understand the nuances.
Right, and even if they do, they may confuse a contractor's CGL policy with the architect's professional liability policy. Actually, if you're a policyholder, you can go to our website and we have a publication that educates clients of design professionals on issues like this. Now, I wish we could name clients as additional insureds on your policy, because if we did, they would not be covered in any way.
Right.
Because they do not perform the professional services, so there's no coverage for them. They think they're going to get coverage. There's no coverage for them. And the other part of it is every professional liability insurance policy has something called an insured versus insured exclusion, which means one party insured on that policy can't sue another party insured on that policy. And if we were to name your client as an additional insured, that means we would never have to pay a claim brought by that claim against you. You might still be in trouble, but your insurance company would be off the hook. So anyway, let's move on to, if you look at the AI language, it really addresses this. In the 2017 one, we tried to clear it up very carefully, and including the additional insured obligations. And I think it and the commentary that goes with it does a very good job of explaining why that won't happen.
And real quick, I will add that we touched on project-specific policies, and I'm not sure we touched on special additional limit endorsements, which are techniques that Victor is very helpful to us in obtaining for clauses that we can't negotiate out.
Yeah, So specific additional limits endorsement does cost you some money because what it's saying is you're having a special dedicated limit for this project. So that increases the insurance company's risk. They're going to charge for it. And project insurance, everyone thought would be the best way to go forever. It doesn't work because it will cost too much money. We've actually had quotes on some projects where for $5 million worth of project-specific insurance coverage, the premium was going to be $5 million because in that kind of a situation, clients simply think of it as a fund of money they can tap at any time. Okay, let's talk about warranties and guarantees. I think you both mentioned that this is a problem in contracts. We're going to do this one and contractual liability right after it. Because I think they both face the same thing. They both really change your liability, and they both fall outside of your professional liability insurance company. When the client says your plans and specifications shall be fit for the purpose intended, right? Or that you will ensure, which is guarantee that something's going to meet codes and standards. Again, you're beyond the normal standard of care. Fit for the purpose intended is really a product liability concept, not a professional liability concept. When you buy a fan or a lawnmower, it has to be fit for the purposes intended because it's been tested out over and over and it's been put into the marketplace. That's not true with the kind of services you provide. Okay, and just to go on to the next one, we'll talk about these together, is contractual liability. You will often have clients who will say, okay, we want you to ensure the requirement to meet all the contractual obligations of this agreement. And again, that's not what professional liability insurance does. We don't look at each of your contracts and say, oh yeah, we need to charge more because they just said this. We look at your practice in general and whether or not what standard of care applies to what you're doing and how in that state it will be interpreted. So when you get contractual obligations, you end up with a lot of business risk. And I think, Brad, do you want to talk about this one?
Well, I guess the best way that I've heard it described is you can only warranty and guarantee things that are absolutely under your control. And so much of what we do is in collaboration with other people. There's no way for us to do that. I mean, a lot of people may say, well, when I stamp drawings, doesn't that mean that I'm certifying or guaranteeing that the building is free from, meets all building codes? Well, there's a difference between guaranteeing it and saying, to the best of my knowledge and ability, I believe this meets the intent of the code. Because if you agree to a provision that says the project as constructed, especially as constructed, or as designed even, will meet all codes, and somehow something goes wrong and you get sued, you can say it's done absolutely correctly. Your consultant can say it's done absolutely correctly. The professional witness can say it's done correctly. The authority having jurisdiction can say it's done correctly. And then the judge or the jury can say, nope, it's wrong. And then you're on the hook for it. And since this may or may not be a negligence issue, your insurance may not cover it.
Right. Remember what we said about warranties. It's just a statement on which the other person can rely to their detriment. And if it proves false, you're responsible no matter what. So obviously it's not, did you meet the standard of care? Did you do what other architects would have done? No, it's just simply that something was wrong.
Absolutely.
And and engineers probably get in trouble more with this than architects do, because it shows up in a lot of studies and reports that engineers do, and then they do the project to meet the requirements of the study and report, and they're held to a guarantee because of the language in the study and report. Glenn, do you have some comments on the contractual liability or warranties and guarantees?
Yes, and I will just say that this that Frank has in orange here, this contractual liability obligation is a very new trend that I'm seeing a lot of. And it's one of the scariest ones that we need to be most aware of because it's sneaky and because everybody does not understand it. And that includes most architects as well as attorneys and owners. And I've had to deal with this on many occasions in the last couple of years. The first thing I always do is to send them a snip from my policy, which is this page, right? That's on the screen right now. So I literally send that to them by email and say, I just want you to know the reason why I don't want to sign that clause as written is because my insurance doesn't cover it. And here you go, there it is. I even had one client that, I don't know, I guess he thought I was trying to pull the wool over his eyes, and he said, well, send me the whole policy. I want to make sure it's in there and not photoshopped out or some nonsense like that. But then that does work. When they do see that, they do understand that it's not covered. They want their project to be covered by our liability insurance. And there's one of my clients, when this first popped up, I've been working with this client for years, for decades, and all of a sudden, this contractual liability obligation appears directly like this in the proposed contract. So after, I'll make this a short story, but after a long negotiation, I basically offered them 3 options. 1, delete that language because we're not covered for it, which is what I wanted, of course. Number 2, we could leave that in, but we would purchase a rider for this insurance to cover contractual obligations, and there is that ability. There's certain other insurance companies that do provide that kind of rider. It's for additional fee and for additional costs. So I made that very clear. And then the third option I gave them was to bifurcate this contractual liability versus the CGL, like we talked about a few slides ago. And after a long period of time, they ended up agreeing to just simply delete this language and move on. So that was a good outcome.
Yeah, this exclusion language, almost identical to this, is in every professional liability policy, not just the CNA policy that we work with, but every professional liability policy excludes contractual liability. Now, it may be phrased in your policy as contractual liability coverage, but it's an exclusion. It's not a coverage. And in this case, the 2 items here, the first one is your contractual liability, right? Including express warranties and guarantees, but all contractual liability that is not caused by your negligent performance. And the second one here addresses that indemnification provision, right? Because in the indemnification provision, if you assume whether it's actual or just the alleged liability of the defense of another party, right? That's excluded. So indemnifications not based solely on your negligent performance of professional services, the underlying cause of that need to indemnify, it's automatically excluded by your policy. And again, every policy. And that last sentence says, if you have that liability anyway, liability and a performance of professional services, then this exclusion doesn't apply because that's your liability based on that business. Okay, design defect clauses. These are showing up in a number of things. Some of them related to condos, but others in just general. And the more you work with contractors and design build projects or other things like that, the more you're going to see this. And Brad, did you want to comment on this one first?
Well, my best friend is actually a construction lawyer who typically sues architects. And we got into an argument about a case he was working on where he alleged that the architect had a duty to check the nail guns for the hardy plank installers. And of course, I objected to that. But the point is that attorneys will go very far to stretch our standard of care and blur the lines between the design professional's responsibility and the construction professional's responsibility. And especially when you're out on the job site, one thing he would say was, if you step on site, I've got you. You have an obligation to really look at everything, knowing that we don't. But if you're out on site, you need to be aware of everything that's going on. And if you're there for just a specific item and you need to write a report that says, I was there just to look at this or deal with this issue and nothing else. A lot of owners will want us to do only minimal construction contract administration services, but one of the problems with that is you get a minimum amount of fee for the maximum amount of exposure. If you're going to do construction contract administration, you need to own it completely and do a thorough job with it because of some of these issues that Frank says they're dealing with now.
Yeah, you really need to define why you're going to be out there as an agent of the owner.
Yes.
You know, what are you going to be looking at? When are you going to be out there? Some owners are very good at saying, I need you out there when they're doing roofing. I need you out there when they're laying a slab. I need you out there. You know, and they'll actually define when you have to be out there so that they can help minimize some of these construction defects, which contractors will start saying are actually design defects. And remember that there's a much different status between you as a professional and the contractor. And the contractor has, once they bid on a project or once they negotiate a price, has complete control over construction means, methods, techniques, sequences, and procedures. Because the contract says, okay, this is your job now, contractor. You do it the way it's best for you to meet the requirements of the contract documents. So they can, if they decided to use a different size nail in that nail gun, that's their responsibility. That's not your responsibility. Glenn, comments on design defects?
Yeah, I would add a caution here about change orders, right? So if there's a defect on a project that needs to be fixed, and the contractor submits a change order, right, for us to approve, and if we think that it was the contractor's fault or somebody else's fault, not ours, and we sign that document and don't submit a request for additional service, then that's something that can come back to bite you in the end. Lawyers, opposing lawyers will make it look like that's an admission of guilt since you didn't ask for it. So it goes right to what Brad and Frank are saying, that make sure that the language relates just to design and not the construction cost repairs. And then if you do think it is not your fault, you should, at that time of approval of that change order, submit an additional service proposal. Even if they don't approve it, it's better to submit it and not get approved. But you have to do it because it looks like, it can be made to look like an admission of error and admission.
Yeah, maybe we should do an hour-and-a-half program on change orders.
Yes.
Mm-hmm.
This was the AIA example, and some of the other concerns that you should have. We'll leave this with you so you can read this. You really do have to be careful, and there's always issues of what was your role on the site? Are you evaluating? Are you observing? For years, the AIA contract said you observed the construction, and in 1997, the AIA president said that's too narrow of a look. Architects will lose money if they only observe. They should do more. He suggested that they supervise construction. That was taken out of the documents in 1963 because it's just not what you can do. But you can do things. You can monitor. You can evaluate. And you have to at times inspect. but you have to define what you're doing.
And Frank, I've had to deal with this issue this year related to COVID. We'll get to that in the last bit, but I've had clients tell me this year when we have not been going to the job site as often, perhaps as we would normally have before the virus, and claim that we are being negligent because we failed to inspect it reasonably in accordance with the contract because we didn't send our staff, across state lines to job sites and tried to do it as best we could by video. So it's a current issue as well.
Yeah, we will get to COVID in a moment, but I have to say that our blog has probably had close to 40 posts on COVID advice right now, and the first one was back February 5th, and it told architects and engineers to immediately talk with their clients about how this could affect the contracts that they sign. Because obviously, if you sign a contract saying you're going to be on a site, and the state won't let you on that site, you've got a problem there. Okay, and we also have some stuff on condos for you if you want to read that. Ownership of documents. From a professional liability perspective, we don't see claims from somebody else using your documents. That is highly unusual. But we do see firms giving up their right to get paid because they transfer their documents inappropriately. And so let's get some comments on this. Glenn, would you like to do this?
And this is also very common when we see this all the time from many of our clients. I do have some success in going back to the AIA language, which I guess is you're going to show in the next couple slides.
We're going to show, B503 also has some alternatives.
But I'll say that of all the things on this list, this is one that we have for a sophisticated client the most difficulty and without leverage in getting it to change. I mean, it just seems clear to them that they should own what they paid for. We try
at times they say they should own it even if they don't pay for it.
Correct. And there's a lot of tricky little language, as Frank has here in this orange box. This work's made for hire, moves it to a different kind of liability. So we try to get that taken out. And then, but I will simply say that we try to get this back to the AIA language, but oftentimes we can't. And I've signed many contracts that leave this ownership with the client. And then Frank, if you move on to some of these other slides, I try to add some of these other things in there, this a license and the indemnification for if they use it. But in the scheme of things, as Frank said, there's very little issues and lawsuits coming out of this kind of thing.
Yeah, it's mostly ownership of documents mostly is a leverage issue. If you give up rights to your documents as they are created, for instance, or if you give up rights to your documents at the completion of the job, and you do not require that all your fees and reimbursables are paid first, you have no leverage to collect your fee. And I think that's one of the big issues that firms are facing. Many owners aren't trying to be nefarious. They're not trying to steal this stuff from you. They do want to be able to use it. And that's why the AIA came up with the licensing language. And there are alternatives in the B103 if you want to transfer the ownership. I did mention when we were talking about this before that architects, unlike engineers, not only have a copyright to the plans and specifications that they create, which are defined as instruments of service. That term came in to avoid the works made for hire idea, which until 1976 was what architects' plans and specifications were. They were works made for hire. They no longer are. But that's when instruments of service is being used. They're not what you're not selling them to the client. They're only expressing the service that you're providing to the client. But we'll see a lot of situations where architects will transfer too quickly, or won't be protected from meritless claims against them from reuse. And you do have to deal with all those kind of issues. Think about all that. But think about the fact that you not only own the documents, but you own a copyright to the documents and you own a copyright to the design. So if a client thinks it's getting something when it says transfer all your documents to us immediately upon creation, you're not transferring the copyright by that. That has to be dealt with separately. And you're not transferring the copyright to the design, which is another right you have that came in relatively recently, 20 years ago, through the Berne Convention. So anyway, if you're a policyholder, we have about a 20-page publication on copyright use. Get a hold of that from our website.
And Frank, back to the last slide real quick. Whenever I've had a client that's been not willing to give up this ownership thing, I've had good success in adding this language 7.3.1, where I'll say, okay, fine, I will sign that language, but please provide this protection for me if you do reuse it. And I've had good success in getting them to agree to that.
In most cases, I think owners are reasonable in that because they do want to be able to use it. They don't want to be held hostage by you if they do anything to renovate the structure or add to it or whatever. But they understand that you know your standard details are your standard details. They understand that you could be sued even though you have nothing to do with the later use of that information, and it makes sense to protect you from that. It's highly likely that will never happen. So it's not like you're putting themselves out on the limb. And as an exchange for the instruments of service, it makes a lot of sense. Okay, let's talk about dispute clauses. You know, we will see, we look at about 1,500 contracts a year for our policyholders. And we will see some dispute clauses that are just immediate, unbelievable, where you know it's the client's attorney who's going to resolve all disputes. Not exactly fair, but we're also seeing a lot of still situations where arbitration is absolutely immediate, and that's probably not the best situation you want to be in. Do either of you have arbitration experiences you want to talk about?
I have been an expert witness on an arbitration panel. I have not done so directly with my firm. And you know, frankly, every attorney, you know, that defends architects and design professionals always tell me to try to eliminate the arbitration clause. And the basic reasons for that is that the rules are harder to you know, be enforced. Rules
you don't
about
have the same protections that you have in litigation. And if you have mandatory immediate arbitration, you don't have a chance to resolve a problem at lower cost, at lower psychological costs, if not financial costs. If you get into arbitration, you're basically saying it's like a lawsuit, it's adjudication, only you don't have the same protections. You don't have the right to appeal. You don't have the same kind of discovery rules that you might have otherwise. So arbitration is not used that often. What should be used is first good faith negotiation. Meet and confer is one way to do that. The AI has language in V503 on that. And you can always decide later, you and your insurance company and the owner can decide later to go into arbitration if you want to do that. But mostly firms will now say, okay, let's meet and confer, let's mediate, and then if that doesn't work, well, let's go into court. And if you go into court, things don't get resolved in court. Things always end up settling before that, right? I think about last year, 4% of all claims against CNA insured architects and engineers were resolved in litigation, and almost all those were third-party claims, so slip and fall type. Okay. Just to give you an idea, here's what the AIA says on mediation. Here's what they say on arbitration. Arbitration is no longer the first choice. And here's that language on meet and confer as an option to add into your. Okay, let's talk a little bit about lender certifications, because I think a lot of people get into trouble with this. Brad, you want to talk about your experience with lender certifications and assignments?
Yeah, these drive me crazy. We've gotten several of these over the last years, and basically, especially with the lender documents, they want, in case their client, your client as well, defaults on the loan, the lender's going to take over the project, and so it kind of triggers some of the assignment of contract provisions within your owner architect agreement. But typically, the lender wants all the rights and privileges of the owner, but none of the duties and obligations. So, and those always need to be tied together. You have all the rights and privileges as long as you have all the duties and obligations that go along with that. They typically don't want to pay us to finish the job. They don't want to pay us if the owner is not paying the lender, he's probably not paying the architect. They don't want to pay us to get caught up. They want us to do whatever they want and there's additional services to finish the project. And then they want us to sue the owner in the end to try to recover any fees that we might be due to finish the project. I can't do that. I can't work for free to finish your project. They usually never ask the contractor to finish the project for free, but somehow they don't see us as adding value, something they need to compensate for. So I always push back on those.
Yeah, and they can get you into the situation where you're owed a lot of money. They're not going to cure that default. They may have you certify things that are inappropriate, even violate your code of ethics or state law. And often we'll see lenders who will just basically rip away everything that's been done and go to somebody else to finish it off. So you don't have, you were planning on doing construction phase services, and now somebody else is doing construction phase services. And if there's any problem that shows up, you're going to be sued because of it.
Yeah. In the certain, like you were saying on the certifications side, a lot of times they're sign a document that says this building is free of any code defects and absolutely in compliance with any ADA statutes. There's no way that we can do that. One attorney that I've talked to here in South Carolina who does a lot of architect owner seminars like this said the only thing that can be certified is gravity. So don't sign anything that says you certify anything for any reason. It always needs to be tied back to standard of care. It's my belief that this happened and this and this. Never say that anything is absolute, because you don't have the ability to guarantee anything.
Right. In your design, you considered all the applicable codes and standards. You certainly can't guarantee that they've been met. You certainly can't guarantee the work of the contractor, which is often the case. And you will see language in these in general that says to induce the lender to make this loan,
Yes.
architects shall certify the following and consent to the assignment of the contract. Well, you know what? That gives the lender a right to go after you directly. That's detrimental reliance on what you're providing them. Lender is not relying on what you're saying to make the loan. The lender is making the loan to make money off the loan. So when the lender says, in order to induce the lender to make the loan, your attorney will tell you, scratch that out. That's not what you're doing. And there are some situations where You can turn a certification around and say, owner can certify that. I can't certify that. You go after the owner for that part. You obviously can certify things you know to be true, but if you certify something that you don't know to be true, you're violating your licensure, if nothing else.
A lot of times I've seen it where either by design or by happenstance, they're trying to get these documents finished at the last minute in a very hurried way, and they say, "Oh, I just need to send something over to you to sign right quick."
Yeah.
And you're like, "No, no, no! I need to have my attorney look at this." Well, you're going to hold up the whole process. Well, you should have given it to me earlier.
That's why the AIA documents say 14 days prior to execution, and
Yes.
it added in the 2007 version this last line that says, "Wait a minute, we're not going to execute certificates or consents that require knowledge, services, or responsibility beyond the scope of our agreement. We can't tell you that when the contractor finishes it, it will be built according to code. We can't do that, and we're not required to do that. So go back to your contract and say, I can't do this. And don't forget your registration laws, because they're a good way to say that ethically I can't do this. Legally, I can't do this. I'm violating my license if I do this. And, again, the concerns are often ownership and use of instruments of service. Are they going to use them with someone else? Are they going to change them, or what are they going to do? Are you asking to give representations and warranties that you can't possibly give? And that by doing this, are you establishing detrimental reliance by the lender, which puts you into a much different position? Now, let's get to the COVID-19 issues. I said we've been addressing this since February because I think there's some real concerns that firms have. We will be tracking this very carefully. We're tracking it to see what kind of claims come out of this. And we'll have a report next year. But when you have a contract that says, okay, you can't, we're not going to modify contract time, schedules, or even how much we're paying you, you've got a problem. If you don't have a force majeure provision in your contract, you may be doing services in a way that is inappropriate, that you can't possibly do. And just to give you an idea, and I've complained about this for decades now, the standard AIA contract does not, design contract does not have a force majeure provision in it. The AIA is relying on that last sentence of section 2.2 to say, okay, if there's some interference by outside forces, supply chain disruptions, government interference, and all that, we cannot perform our services as expeditiously as possible due to something outside of our control. That we'll see how that holds up, because even though starting in February, you've seen owners and contractors and others say we're all in this together. No one has been in this together. Contractors from day one have been setting up claims to bring against owners, and those claims may come against you. The ASOA provision, which is actually a group headed by a former head of the AIA Documents Committee, does include a force majeure provision in its contract. And I think landscape architects are much better off because of that.
And for contracts that I've had to negotiate this year, I've had good success in adding the word global pandemics to the list that was on that previous slide, just to be sure.
And if you look at a federal contract, they have a very good force majeure provision that includes epidemics, and that gets you out of it. What we're seeing now, and I think this is being passed around by some owners group, is this language. And this is in a design contract, but I'm sure the similar thing is in a construction contract. And what this basically says is what that last highlighted area says. Even though there may be impacts because of this pandemic, right, you're not going to get any more money, and you're not going to get any more time, right? This is, we can adjust it. You can't demand adjustment. And in a contractor situation, you know, even though contractors are saying, oh, this is so terrible for us, in a contract for construction, if they have to now buy masks for all their employees, that cost gets passed on to the owner. If they're delayed because of government interference, that cost is passed on to the owner. So all those costs are passed on to the owner. Contractors are going to make a lot of money off the delays and extras. Except if they sign something like this in their contract, which will keep them from doing it. And you know, you have to keep in mind that, okay, we talked about the standard of care, and you can argue that because of COVID-19, the standard of care has changed, right? We can only do what was reasonable at the time the services were performed. But you end up with a conflict if you sign that contract already that says, I will be on site to inspect, I will be on site to certify the contractor's application for payment, and I will be on site to evaluate the quality of the work. When in fact, you can't. And if you don't have a way out of that, you're in trouble. And if the client is saying, well, you know, you can have a video hookup to the site, that contractor is not going to show you where the problems are. It's going to show you what the contractor wants to show you, no matter what you ask for. So you could be in a situation where you're saying, yes, the project was adequately performed when it was not. That's going to come back and haunt you. So you need to talk with owners right away on contracts you have that exist, and you need to look at contracts that you're entering into and modify them so that there is this possibility of change. In some states, it's almost back to normal in the design and construction industry. But when that second wave or third wave, or maybe fourth wave of the pandemic starts, it could switch back immediately, which means you could be having additional costs, you could be having additional challenges, and you could be having additional contractual obligations that you can't possibly meet. So, you know, be very careful. And any final comments on COVID-19 before we go on?
I would say for proposals and contracts that I'm writing this year, along what you've just said, is we're trying to be very careful to manage the expectations, to lower the expectation, and to clearly define what activities we're going to do on site versus what we are going to do from the office by video. Which is just good practice anyway.
Right, the fairer you can be on that, the better off. And you know, again, our blog, which anyone can read, you don't have to be a policyholder, has about 40 things on dealing with COVID-19. So let's close this up with a few summary slides. And one, you can survive even the worst contract. And part of that is through your communication, right? You know, don't let that client become an adversary. Don't let that contractor turn that client into an adversary. Communication is a big part of it. You know, clarifying the vague requirements and the owner's duties, you can do that. Even if you sign the contract, you can keep the client informed. The more communications you have, the less likely it is the client's going to sue you. And about 2/3 of all claims against design professionals are straight from clients. So if you can manage that relationship, you're a lot better off. And you have to document. You have to create the record of things like what the client decided and what the client authorized. Remember, you're making recommendations, the client is making decisions. And anytime in your documentation that you can establish conformance with the standard of care, refer to what others would have done, right? we are performing these services as others performing services on this type of a project would do. Clarify that whenever you can. And again, your quality control efforts, and they may be hit because of COVID-19. It's hard for some firms to do quality control, quality assurance procedures when they're doing it remotely, when their firm is now in people's basements. But you know, look at your project management procedures. You know, look at what you're going to do on this project, and both internally and with your client and other stakeholders, discuss what is expected of you, because those expectations have to be reasonable, have to be something that you can meet. Otherwise, you're going to be trapped into a situation where a dissatisfied owner is going to sue you no matter what. Review your design efforts and your deliverables, right? That's basic to your quality control efforts. And that may include having a peer review by someone else, either someone in your firm who's not on the project or someone in another firm. Having a peer review is one way you can save a lot of money on your insurance. And you know, that internal review and deliverables before you release them, don't rush them out no matter what the situation is and what demands the client is making. You have to have enough time to do your services. Okay, gentlemen, any final thoughts that you may have on these issues, or anything else that you want to advise?
I would add the best advice I've gotten when I started out in this profession many years ago, which came from a lawyer friend of mine. And he asked me the question, what is the number one reason that begins lawsuits in this profession? So I rattled off, I don't know, bad contract, you know, bad drawings, errors and omissions, you know, delays, on and on. And he said, no. The number one reason is anger, right? And he's right. And it's all of the things that Frank just went through: is communicate, correspond, be clear, be professional, be nice. And if you do all those things, even with a bad contract or bad drawings, that'll go a long way towards avoiding having to deal with a bad lawsuit.
Great, thank you. And Brad, any final comments?
Yeah, I would say, you know, a lot of architects say, I don't want to be an attorney, I don't want to be an insurance professional, I just want to do architecture. But you know, while I understand where they're coming from, you need to know enough about the implications and the obligations of what you're signing in a contract, so that you don't sign a contract where you agree to execute yourself. And I think you can survive a bad contract. Always a good contract's better than no contract, which is better than a bad contract. But if you can understand a couple of fundamental issues up front, know what to look for, and know that you need to read the contract, and then your insurance company is there to provide contract review on the front end, you're in a better position to be able to negotiate something better for yourself than just rolling over and saying, I have to sign it because I need the work.
Right, and if you're one of our policyholders, get onto our website. There's a ton of contract information that can help you. If you're an AIA member, or even if you're not, you know, there's you go to AIAcontract.org. It has a lot of educational programs and a lot of explanations of contract language, links to a number of YouTube videos on the AIA channel that talks about AIA contracts and project types and what you should be concerned with. And of course, things like B503, which is free to anyone. You don't have to pay for that contract document service. You know, provide you with some alternative language to the standard language as well. Okay, with that, I think we're going to end this. Please look for that survey in your email box tomorrow. Fill it out if you want continuing education credits. We will register, if we get your AIA number, you with AIA CES if you're a policyholder. If you're not, the AIA Trust will do that for you. But we need your AIA number with the exact number of digits. And we would like you to fill out that survey so we know how we've done it. And gentlemen, I thank you, and I look forward to doing this in the future with you.
Thank
Bye
you,
now.
Frank.
Thank you, everyone.